From supplementary list, item number 1.
This against the order passed by Central Administrative Tribunal.
A little louder, please.
Against an order passed by Central Administrative Tribunal,
Yes.
Guwahati bench, my lord. The respondent had filed caveat. We have served him copy, my lord. My lord,
Yes,
so
I
today I am
will
praying that if the notice can be issued and the matter may be fixed for hearing, my lord, final argument.
But they are already appearing.
They are appearing, my lord.
Yes. So issuance of notice can be waived.
My lord.
Are you asking for any stay? What is the order?
My lord, order
I have
for-
an objection, my lord, regarding stay.
My lord, what I pray with the matter will be heard next week or after 2 weeks as a lot
So what
convenient.
is the order? What is the
The
order?
order is for payment of medical. The respondent was serving in ICA, Indian Council of Agricultural Research, who have a center here in Shillong, my lord. And after his retirement, for the purpose of medical treatment, because there are two schemes under the rules, my lord. One is that they get a fixed lump sum allowance along with their pension, my lord. He availed that, my lord. But for certain medical expenses, they claim the amount, my lord, which otherwise they are not entitled to, my lord. And the learned tribunal has directed us to give that also.
What is the amount?
Amount is roughly 2.5 lakh something, but this is a recurring expenditure, my lord, because the wife of the respondent is suffering from some major disease, my lord, and this is a recurring expense.
Up to now, how much is outstanding?
At 2.5, roughly 2.5 lakh rupees, my lord.
And how much expenses are involved every month?
This is for dialysis, my lord.
Sorry?
Dialysis.
How much every month?
Every month, nearly 20,000. Every 3 days in a week, 3 times she has to execute the dialysis.
According to the order of the tribunal,
Tribunal order is that
how much is payable now?
payment is recurring, my lord.
No,
So
it is
from
recurring
2021,
till the date of the order. How much is
10 lakhs he has submitted bill as per tribunal order
till date?
till date.
And recurring is how much per month?
Recurring is every week, thrice in a week. She is doing dialysis, executing
So
dialysis.
how much a week?
That is 15,000, 5,000 something. So it is the dialysis is required to save the life of the.
For the you have already incurred the expenses up to the date.
Yes, I have already incurred. I have exhausted all my resources. My retirement benefit has already gone. Now I have no other alternative. They have to reimburse as per rules.
Keep that amount in a separate account, earning interest. With the government, they go to separate.
And director has given the approval for dialysis in Bethany Hospital.
What is seeking those?
Reimbursement. 10 lakhs of career and 60,000 a month. You do this,
My lord.
you keep 10 lakhs in a separate account,
My lord.
interest bearing account
My lord.
with yourself.
My lord.
And 60,000 per month is the recurring expense.
That will depend, but that is variable, my lord. It may not be a fixed amount, but it appears that lump sum it will come around that figure, my lord, per month.
And say 60,000 per month. How much per month is the?
Per month, nearly 60,000.
And keeping into account the recurring expenses, you keep a further sum of around 5 lakhs in a separate account. And we will hear out this matter.
Well,
Yes, please take down. Where is the impugned order?
Impugned order at page
13. Well,
13. Operative portion from page 19, my lord. Page 19 to 21.
We admit this writ application from the judgment and order dated 23rd July 2024, passed by the Central Administrative Tribunal Guwahati Bench in original application number 043/99/2023, Porimal Ghosh versus Union of India and others. By the impugned judgment and order, the learned tribunal has directed reimbursement of the medical expenses incurred by the writ petitioner for carrying out hemodialysis of his wife. Quotation, as a special case, unquote, as per CGHS approved rate, quotation, in lieu of fixed medical allowances, unquote, within a period of 2 months from the date of receipt of a copy of the order. Paragraph, it is submitted by learned counsel for the petitioner that the expenses so incurred up to the date of the order of the impugned, the date of the impugned order of the tribunal was rupees 5 lakhs or so. And that the recurring expenses for carrying out the above treatment is about rupees 60,000 per month. Well, we propose to hear out this application on the existing papers. Next line, on the prima facie case made out by the petitioner and considering the balance of convenience, comma, as an interim measure, we direct the Appellant Union of India Yes, please. What did it say?
We direct the petitioner Union of India
India to set apart and keep in a separate interest-bearing account with a nationalized bank in the name of the union a sum of rupees 15 lakhs comma to the credit of this proceeding. Full stop. The details of the investment shall be intimated by the appellants to the respondent. When do you want to argue the matter?
Convenient to lodge after 2 weeks
After 2 weeks.
or 3 weeks.
In the meantime, I'll file the affidavit of objection before the
Yes.
next date.
List this application. On 23rd.
And I will file the affidavit of objection before that date.
No, we have said that all the papers are there.
No, I will file this affidavit of opposition. They have filed the writ petition.
Affidavit is not required, my lord, because
But those papers are there before the tribunal.
Yes, everything is there here.
Still you wish to file?
I will file my short everything. No.
Sir, if you wish to hear it out on the existing papers, you write it out. We direct that affidavits may be exchanged. In this matter, in the following manner, colon. Affidavit in opposition by (25th October). You make it 30th October. Affidavit in reply by 11th November. List on 13th November. Where directions have been given for affidavit, please add the yes. Call the next matter, please.
Item number 2.
Mother, please.
And this is an appeal against the order passed by Central Excise Tribunal, Kolkata, my lord.
Is there any delay?
There's a delay also, my lord, 162 days. I'm praying for notice to the respondent, my lord.
This is under section 35.
35G, my lord, capital G.
This is an appeal under section 35, capital G. Of the Central Excise Act,
My lord, 1944.
1944. There is a delay of about 144 days
162 days.
or 162 days in filing this appeal. This is accompanied by a stay application also.
We have not filed a stay application.
But what is this MC?
The continuation of delay, my lord. Stay application.
So this is only a base case.
Only miss case is listed today because appeal will be registered only after the delay is controlled.
Then you write what I said. This is an appeal. No, this. list this application. On 6th November. 6th November. List this application on Swen's footstep. Let a formal notice be issued to the respondent and served upon them by yes. Is one matter, two matters? One. Miss case.
Item number 3.
Your Lordship, this related writ appeal is filed against the order dated 10/6/2024, passed by the learned single judge. I take to your Lordship at page 29 of my memo of appeal. Page 29 is the impugned order against which I have come on writ appeal. This is a order dated 10/6/2024 is passed in 2 writ petitions. So far, we are concerned only with WPC 266 of 2019, which was disposed. Your Lordship, I take page 32, the last para, operating portion. In view of the above, this set of 2 writ petitions are also dismissed in terms of the judgment and order dated 5/6/2024, passed in WPC number so and so, no cost. Your Lordship, my writ petition was dismissed in view of the order passed by another coordinate bench in 2 writ petitions, Your Lordship. The other order, Your Lordship, is at page 123. Your Lordship will just come to page 123. 123 is the order dated 5/6/2024, which is passed in WPC number 343/344. Now, by this order, on merit, the writ petitions were dismissed by the learned single judge. And the same order was made applicable in my case. Now, the order dated 5/6/2024 is assailed by the writ petitioner on a writ appeal before this honorable court. And this honorable court, Your Lordship, has passed an order on the order dated 30/7/2024, page 150. Your Lordship will see page 150. The writ appeal is admitted, notice. The proceedings before the authorities can continue on day-to-day basis without adjourning the matter beyond 7 working days at any point of time, and the final order shall be kept in abeyance. It is open to both the parties to move this court depending upon the urgency. It is needless to mention that the condition mentioned supra is only on the condition that the appellant shall deposit 30% of the demand within a period of 1 month. In case of non-deposit of the amount as ordered, it is open to the respondent to proceed with the coercive actions. So, Your Lordship, precisely my case is this, that my writ petition was dismissed in view of the order passed by a coordinate bench. And that order is under challenge before this honorable court in a writ appeal. And this honorable court has already admitted the appeal and passed an interim order. My prayer, Your Lordship, is this, that pending hearing and disposal of the condemnation applications, I am also entitled to the same protections which were given to the other writ petitioners, that is, deposit of 30% of the demand amount involved in the case, Your Lordship. Now, there is a delay of 42 days. The delay occurred, Your Lordship, for 2 reasons. One reason is this, that there are 3 co-sharers. Though the lease is 1, but there are 3 co-sharers and they were all writ petitioner in the writ petitions. After the judgment was passed by the learned single judge, one of the co-sharers died. And after his death, the wife stepped into the shoes of the husband and has filed this writ appeal. And there were certain, the entire family, Your Lordship, was under bereavement. So there is a delay of 42 days. This is one reason. Second reason is this, that since my writ petitions was dismissed in terms of the order passed by the another coordinate bench, and that order is already under challenge before this court, and an interim order is rendered, and I was under the impression that I will also get the similar benefits.
Which are the other writ appeals?
Other writ appeals, Your Lordship, are 344. I just read.
344. Page 150.
Page?
150.
Page 150. Your Lordship. That is writ appeal number 44 of 2024. And writ appeal numbers are page 123, Your Lordship. Page 123. Other 2 writ petitions numbers are 343 of 2022 and second one is 344 of 2022. There are, Your Lordship, 3 coalesces. I am representing only one. Other 2 coalesces have not approached before, have not approached this court for any protections. So the order which Your Lordship may render will be applicable only in the case of the writ appellant hearing, because there were 3 coalesces. And the tax demanded, the amount involved in this is 20 lakhs 20 lakhs, 21 lakhs 10,864. And this court has directed that after 30% of the 30% deposit. Now, along with the condonation application, Your Lordship, I have also filed one application under section 151 for passing an ad interim order pending disposal of the condonation applications and the writ appeal. Last order. The matter was listed earlier.
The other two writ applications are WA3.
WPC number
Here it is WP3 within bracket 1, within bracket 1 to 9.
page 123, Your Lordship. Other two writ petitions.
No, but where are the orders?
Order is at page at page 150. This matter was earlier taken on 28/8/2024. The matter, final, and no order could be passed because non-availability of a bench. If Your Lordship permit me, I may read the order dated 28/8/2024 passed by this honorable court in this matter only. Para 5 lists this matter before any other bench without one of us. The concerned authority, however, are at liberty to consider the case of the applicant in view of the non-availability of a bench presently to take up the instant appeal.
So you have 3 appeals.
No, there were 3 writ petitioners.
So 2 appeals are already pending. This is the third one.
Those are different appeals, Your Lordship. And so appeal is pending.
May I clarify, my lord? My lord, 4 writ petitions were filed by 4 petitioners, my lord, before the learned single judge.
All dismissed.
My lord, 2 were disposed of by speaking order, my lord, after hearing the parties by justice. Thank you, my lord.
And 2 are pending.
2 were pending in the other court of Justice Bhattacharya, my lord. Then the judgment passed by Justice Thank you was placed because they were identical cases, my lord. And the court of Justice Bhattacharya also dismissed the 2 matters, referring to the judgment passed by the learned single Justice Thank you, my lord. So now against the order passed by Justice Thank you, 2 appeals have already been preferred, my lord. Writ appeal number 44 and writ appeal number 45, where certain interim orders have been preferred by Your Lordships, my lord. Now, the other matter, my lord, which were disposed of by Justice Bhattacharya, the present appeal is being filed. Now, here what happened, my lord, in the original writ petition, there were 3 writ petitioners, my lord, in one writ petition. Now this present appeal is preferred only by one of the writ petitioners, my lord. The three brothers, they were the joint lessees of the land, of the cantonment land, my lord. So two have abandoned their claim, my lord. Only one of the co-sharers have preferred the present appeal.
Writ also taken and in the same interim order of. We are condoning the delay. But here the only MC is in the file.
Lordship,
Miscellaneous case.
miscellaneous case, give me the list.
But the procedure followed is that only after the delay is confirmed, my lord, the appeal is registered, my lord.
Item number 3, your lordship is listed on, writ appeal is listed on a tender number. And the stay application is also listed on a tender number. When it is admitted and some order is passed, then this tender number goes and the regular number will come. WA number 3T29 of 2024, this is a tender number.
Temporary number.
No, tender number.
We condone the delay in filing the appeal. By directing the Registrar General. Now you begin the sentence with, as sufficient cause has been shown, we condone the delay by the appellant. We condone the delay in filing the appeal. Next, we direct the department to register the appeal. Yes. These appeals and the connected applications. कॉपी दे बेटे. But these writ applications are to be listed along with the other two appeals. This writ appeal is to be listed. Other two appeals indicated in the cost title. This is over.
We have means.
Yes, call the list.
From the daily list, item number 1.
Lordship, that the interim order which is passed in the other writ appeal should also be made applicable to me.
Where have we kept the matter? Where have we kept those matter? 3 appeals?
Fix. Not yet fixed.
We have directed the matter to appear for admission. When? To appear in the list again. Item numbers. 3.
Lordship,
Yes, 1 appeal plus 2 appeals together. Item number 3 of the list.
yes, these are the
Yes.
this release. Once a number is given, then this
Yes, yes.
cannot.
You are referring to which appeal?
Your Lordship, I am referring to the writ appeal number 3T29, which is a tender number. Now, Your Lordship has condoned the delay and admit the appeal, and Your Lordship,
And directed it to be listed for admission.
Your Lordship, the identical appeal, writ appeal are already admitted.
Are they appearing in the list?
Yes, not today, they are not, these are not appearing in the list.
But those are fixed on 1st of December, my lord.
Your Lordship, I am asking for the interim protection pending disposal of this admission hearing, if Your Lordship is fixing it for admission hearing.
What is the interim protection?
That order, Your Lordship, which has been passed in the other two identical writ appeal, that is at page
150, Your Lordship.
150, 150.
Yes.
If Lordship permits me, in fact, Your Lordship, he should have given the notice. I am for the cantonment, restaurant number 4. What he is asking for, similar order past page 150 in the other two writ appeals. That 30% they have to deposit 30% of the amount he has to deposit. That interim protection is asking.
Of my share,
No, not of his share. We cannot say that of his share. He is bound to deposit 30%, then you decide.
see, this is
No.
cantonment land.
No,
This is not a cantonment land.
Whatever it is.
Not necessary. You said that you are not a party, necessary party in the case. Your Lordship may say that the order dated 30/30/7/2024 passed in WA number 44 and 45 of 2024 will also be applicable in this case, so far the writ appellant is concerned.
This is the number, WA 44,
Yes, Lordship.
44.
44 and at page 150.
Yes.
44 and 45, there are two appeals.
Have you written anything?
My lord, if I may, small submission, my lord. Here what happened, my lord, the three brothers were the joint leaseholders in respect of one plot of land, my lord. Now, while filing the writ petition, all three brothers were the writ petitioners, my lord. Lordship will kindly see that at page 36.
So that this submission you make when we take up the appeal for admission.
My lord, Lordship granting it because it will come to the question of deposit of 30%.
30% deposit. Whether he is deposit singly or jointly, there is not our concern. Because this has not been partitioned. The quality has not been partitioned.
See your affidavit. You said you are not a necessary party.
I'm respondent number 4. Although he has not given me notice, I'm defending my own office.
When have we directed the matter to appear again? What is the last sentence?
Will the appeal and the connected application on
And thereafter have said something about keeping the money apart and all that. list the writ appeals along with all connected applications. Up to 26, no? We have kept matter to be listed. Matter to be listed 26. Department of the Code or registry? Registry to register the appeal. The registry is directed to register the appeals forthwith, since the respondent is represented by learned counsel. Issuance and service of the notice of motion is waived. Considering the prima facie case and the balance of convenience, the interim order made on 30th July 2024 will come. This interim, we make an interim order, but to be
Considering the prima facie case and the balance of convenience, the interim order made effective July 2024.
after
In WA number,
yes, in
WA number 44,
page 150.
When it's coming.
Yes, all the rest.
Your Lordship, so far the writ appellant is concerned, this order will remain operative. So
Yes,
far,
for a limited period of time.
yes, Your Lordship. So far the writ appellant is concerned, not because I am not holding the brief of other co-lessees.
Yes, what did you read? Just
Considering the present proceedings and the matter of provisions interim order made on 13 July 2024, passed in the Writ 44, will continue.
Continue to apply in this case, so far the writ appellant is concerned.
let us see. 15 lakhs you deposit and no, this,
One third.
no, this will be kept in abeyance to, no, the interim order will continue for a limited period, we have said, huh? Till 6th December 2024 or until further order, whichever is earlier. Let the appeal be admitted, then the order will continue.
Lordship, but only one thing, so far the writ appellant is concerned.
All right. It goes without saying that this interim order will protect the appellant only. That's all.
Your Lordship, I have a prayer, Your Lordship, because the property has not been divided. This is very important. This is a joint levy. So 30% then he wants to give only for his person, how can we without division partition?
That, Your Lordship,
I
the
don't think-
DO, Defense Estate Officer, will decide. And my friend is representing only the Shillong cantonment, and the land does not belong to the cantonment. And he has filed the affidavit that cantonment board has got nothing to do. It is the Defense Estate Officer, because the land is outside the cantonment.
My lord, I appear for Defense Estate Officer, my lord. Land is under the management and control of Defense Estate Officer.
Not the cantonment.
Now, my lord, here what happened, my lord, one plot of land, there are three brothers who are the joint lessees of the property, my lord. Now, because of non-payment of rent, my lord, on the lease rent of that, the Defense Estate Officer is initiated proceedings under Public Premises Act, my lord. Against that, they came before this honorable court, my lord. Originally, there were three writ petitioners. Now, while filing the appeal, only one of the petitioners are before your lordship, my lord. Two of them have not preferred to file any appeal against the order, my lord, of the learned single judge. Now, if the appellant say that they'll pay only 1/3 of his share, my lord,
I did not say that, sir.
my lord, in that case, my lord, we should be given the liberty to proceed against the remaining two, my lord.
Yes, that's right.
Because if he deposits only 30%
Let
and
us see whether we admit the appeal or not, then we will take the decision.
but
Your Lordship, then in the meantime, she needs to serve copy on respond number 4, because the notice went through a cantonment.
Your Lordship, anyway, I'll give him another copy. Copy was given.
No, not a single copy has been served. Review for delay condemnation also, nothing has been served. Still, I'm just not saying anything.
Advocate on record. So the appellant will serve a copy
To the,
of the first papers upon the respondent's advocate record.
Obvious, much obliged.
From the daily list, item number 1.
Yes.
my lord, this is against the order passed by Central Administrative Tribunal, my lord. But here what happened, the respondents herein, my lord, are senior laboratory technician in Negris, my lord, which is a medical college in Shillong, my lord. Now, my lord, this pertains to senior technical laboratory technician. In respect of junior technician also, my lord, an identical order has been passed by the learned tribunal. And against that, we are filing the writ petition today, my lord. So, my lord, I was praying, my lord, because the issues involved are identical, my lord. Once we file that, both the matters can be taken up together, my lord.
Yes, please.
My lord, I was praying if the matter can be taken up after 2 weeks, my lord. In the meantime, we are filing another petition which is identical in nature, my lord.
Is there a stay application also? No, WP. No.
We have made interim prayer in the writ petition itself, my lord, at page 12.
Yes, what is this matter about?
My lord, this matter, here what happened, my lord, the respondents are working as laboratory technician in the medical college, my lord, Nigrinj, my lord, in Shillong. They were recruited, my lord, in a pay scale of 4,500, some 15 to 20 years back, my lord. They approached Central Administrative Tribunal saying that their entry level pay would have been 5,000 rupees instead of 4,500, my lord. Today I was praying for 2 weeks time, my lord. The matter can be heard after 2 weeks, my lord.
How many respondents are there?
There are about
I'm repeating to respondent, Your Lordship.
All.
10 responses.
You wish to file an affidavit or?
The records are available. She has given all the petition.
Or you could also argue it out on the existing facts and evidence.
In fact, for admission, Your Lordship, I don't think I'll be going to file the affidavit because this judgment is covered by the Supreme Court decision. On the basis of the decision, they have given the, with regard to the revision of the pay. And she's asking for a little accommodation for 2 weeks, I think. Let it come out.
No, do you wish to file an affidavit or not? Please tell us. Or can we hear it on the existing papers?
I think it can be heard on the existing papers, my lord.
Or the existing paper, it can be heard. Yes.
This writ application against